Hi, good morning. Thank you very much for everyone joining us this morning. I think based on the attendance that we have this morning, this is a very hot topic that is intriguing many of you out there. The Cybersecurity Act 2024, as you know, has just been enforced a couple of weeks ago. And based on the questions that you guys submitted during the registration process, most of you were interested to know, number one, if your company is under this particular act, whether you have to comply with it, and secondly, what exactly do you need to do in order for you to comply with this act. So these two questions are definitely the ones that we'll be answering in our today's session. But before we proceed further, I would just like to introduce myself. So my name is Ilyas Sapian. I am Director of Internet Now. Internet Now is a company that focuses in providing cybersecurity products and services. This is our 25th anniversary. So we've been in the market for 25 years. And myself, I am a cybersecurity practitioner with over 25 years experience. One thing that I am not, so this is a disclaimer, I am not a lawyer. So today's session is more of an information sharing session for me to share with you what I have learned over the last few months regarding this particular act. And this should not be treated as a legal advice. I urge you to talk to your own legal department before you make any final decisions related to this act. Okay, so now that that is out of the way, let's proceed with our topic of the day. So what exactly is Cybersecurity Act 2024? So this is actually the first act that we have addressing cybersecurity specifically. This act is more about how companies that are crucial in the country's economy, how they should protect their critical system. So the act is about protecting the national critical information infrastructure, NCII. So given that today the country runs a lot on IT, everything from our transportation to our energy to our water to our banking to our government, a lot of it actually relies on system that's available on the internet. It's obviously important that all these systems safety and security are taken seriously by the companies that are providing these services. So the government has taken the initiative to introduce this law to make sure that all companies that are providing this critical infrastructure, they take the necessary measures to ensure the security of the system. And if they fail to do so, they will be penalized. Okay, and as you know, the government has also been very active in attracting new technology, new investments from overseas, specifically in the area of AI, in the area of energy transition, in the area of data center. Obviously, we must have a very strong law to ensure that the services that are provided by these investments in Malaysia will be reliable and will be secure from cyber attacks. So in the past, we've had other laws that deal with IT security with cyber attacks, but they were not really similar to whatever that we have with Cybersecurity Act. So before, we've had the Computer Crime Act 1997, the Communications and Multimedia Act 1998, and of course the PDPA, the Personal Data Protection Act 2010, which is to protect the consumer's data, and last but not least, the Penal Code. All these have been used to prosecute cases related to IT, as well as IT fraud. But none of them actually looked into protecting the national critical infrastructure systems, which is what Act 854 is all about. So let's have a look at the timeline in terms of how this act came about. In March this year, the lower house, the Dewan Rakyat, passed this act. A few days later, Dewan Negara proceeded to pass it as well. And June this year, it was gazetted as Act 874. It came into enforcement last month with the introduction of a number of supporting regulations. So, talking about regulations and acts, I think it would be good for us to get the definitions out of the way to begin with, because this is important to answer the questions that many of you would have later on in terms of what exactly must be done in order for you to comply with this act. So, in our country, as well as many similar legal systems under the Commonwealth countries, we have the Act right at the very top. So this is the highest level of documentation related to a particular law. So in the case of the Cybersecurity Act, we have this Act 854, and it deals with the cybersecurity law. So an act is legally binding to all members of the public, and examples of such acts include, for example, we have the Companies Act 2016, we have the Employment Act 1955, Income Tax Act, Penal Code, and the Banking and Financial Institution Act. Normally, the Act itself lays down the general concepts of the law, but it may lack finer details in order for the law to be enforced. So we would then need to have set of regulations. A regulation is the second highest level of documentation related to that particular law. So it is made to support the act by providing more details, as I mentioned just now, and it's also legally binding. So if we take, for example, the Income Tax Act 1967, it has a set of regulations which further refine the details that's needed in order for the act to be enforced. So for example, we have the Income Tax Treatment of Losses Regulation 2010, Income Tax Deduction for Contribution for Approved Retirement Funds, Income Tax Exemptions. This is update number 10, for example. Income Tax Regulation on Installment Payment. So this describes how, if you're allowed to pay your tax in installment, how it should be done. So a regulation basically gives you more details in terms of how a particular act is supposed to be enforced. And last but not least, we have code of practice. So code of practice is a guidance. It's the third level. Its purpose is to define the minimum level that you need to meet in order for you to comply with specific element in the act or regulation. It's also known as a guideline. So let me give you an example. One of the questions that many of you ask is, what you need to do in order for you to comply with the act. So one of the things that the act actually requires you to do is to do risk assessment for your system. So talking about risk assessment, we need to know what kind of risk assessment, what's the scope of the risk assessment that we need to do in order for us to comply? Do we just need to do, for example, penetration testing of our public-facing websites? Do we need to do internal penetration testing? Do we need to do penetration testing of our Wi-Fi system, for example? So in order for us to know what must be done, okay, the minimum that we have to do in order for us to comply, in this case, in the area of risk assessment, we need to have the code of practice defined. So at the moment, the code of practices have not been defined yet, but they will be released, and that will give us the guideline in order for us to know what exactly is the minimum that we need to do in order for us to comply. So coming back to the income tax example, these are examples of guideline or code of practices that is related to the Income Tax Act. Okay, so last month, a set of regulations were released for this act. And with the release of those regulations, the law is ready to be enforced. Okay, so this was done on the 26th of August. 4 regulations were actually released. So the first one is cybersecurity compounding of offences regulation. So this tells how the government will compound or fine any offences. The second one is regulation on licensing of cybersecurity service providers. So this one actually tells how service providers have to be licensed. Okay, they have to get their license. Who and which service providers are involved, what's the process to get the license, what's the fee with regards to the license as well. The third one was the notification of cybersecurity incidents. So this regulation describes how you need to make the reports when you have a cybersecurity incident. The fourth one is actually on the period or the frequency of risk assessment and audit that needs to be done by companies that are affected by this particular act. So we have the act, and then these 4 sets of regulations were released, and the act started to be enforced. So right now, we are still waiting for some code of practices, some guidelines, in order for us to know in more detail in terms of what needs to be done. If, let's say, for example, for the risk assessment and for the audit. Okay, now let's have a look at the main elements or the main components of this particular act. So we have actually 5 different main components. The first one is the committee. So the committee is actually the highest body that has the most power when it comes to enforcing cybersecurity law here in Malaysia. So this committee is actually led by the Prime Minister. Okay, we'll go into a bit deeper into the committee shortly. But the second highest would be the Chief Executive of NACSA. So NACSA is our National Cybersecurity Agency. Okay, so with introduction of this act, NACSA has been propelled forward to take the lead to enforce cybersecurity laws here in Malaysia. So a lot of power has been given to the Chief Executive of NACSA as well as his team to enforce the cybersecurity laws here in Malaysia. We'll go into more detail in that later on. Now, the companies that are affected under this act, they are called NCII entities. They are the National Critical Information Infrastructure entities. So you guys that have attended, many of you are wondering whether your company will be one of these NCII entities. So you will need to be designated. That means at NACSA would actually officially designate you as an NCII entity, and then you have to comply. So it's not like automatically everybody has to comply with this act. No, you have to be designated in order for you to be complied, in order for you to need to comply with this act. Yeah. And there are 11 sectors that the Act have selected or identified to be critically important to the nation. So these 11 sectors, they will have an agency that lead the sector. So we call this as NCII sector leads. So the sector leads, they are responsible for helping the chief executive of NACSA to come up with code of practices for that particular industry. So for example, I know that today we have people from the aviation industry. So if your company, let's say for example, you are an airline, you are selected as an NCII entity, okay? Your sector lead would be people like the civil aviation camp, Ministry of Transportation. So these guys are the one that actually would be advising the chief executive of NACSA what are the companies under their industry that should be designated as an NCII entity. And they also will be advising the chief executive in terms of the scope of, for example, the risk assessment that needs to be done. They have the expertise to know what are the critical applications that are involved in the industry that needs to be protected. So they will make this recommendation to the chief executive in terms of the scope of the protection that needs to be in place, and that will be included as part of the code of practice that will be published by the chief executive. Last but not least, we have service providers. So these are companies that provide cybersecurity services like Internet Now. So we need to be licensed moving forward in order for us to provide the services. So I know that some of you guys who will sign up are also service providers today based on the questions that you submitted. So depending on the kind of service that you provide, you might need to get yourself a license from NACSA in order for you to provide these services moving forward. Failing which, you can be fined. Okay, you can be fined. Okay, so let's have a look at all these items one by one. First, we start with the committee. So as I mentioned, the committee is chaired by the Prime Minister, and he will be assisted by the Chief Executive of NACSA, okay, the Chief Executive Officer of NACSA and his team. And then, as members, we have ministers from various relevant ministries, all those that are involved in the national critical infrastructure. And we will also have two cybersecurity experts who will be designated by the chair to help to advise the committee. So next, we have the chief executive of NACSA. As I mentioned, the chief executive has a lot of power with the introduction of this act. NACSA actually has the power to search, to seize evidence in any of the NCII entity. They also have the they basically will be the one that will be drafting the policies with regards to cybersecurity in the country as well. So firstly, they will be advising the committee, as I mentioned to you just now. Secondly, any policies that come out from the committee, from this act, they will be implemented and enforced by NACSA. So NACSA will look into the details in terms of how these policies should be implemented. And they will be the one that will be issuing directive to the NCII sector leads and also the NCII entities. In fact, they will help to identify, well, they already have actually identified the sector leads a couple of weeks ago. Okay, so talking about the sectors, there are 11 sectors, as I mentioned to you just now, that the policy drafters have identified as being nationally critical. So we can see here, we have the government, banking and finance, transportation, defense and security, national security, information and communication, healthcare, water supply and wastewater, management, energy, agriculture, trade, industry and economy, and last but not least, science, technology and innovation. So these are the 11 sectors that have been identified. So if you are under any of these sectors, there's a good chance that you will be designated as a NCII entity. So the job of identifying those companies that are NCII entity will be done by the sector leads. Okay, so firstly, the sector leads will be designated by NACSA. Okay, and issued out by the committee, and the sector leads will then identify the NCII entity. Okay, as I mentioned. So since these sector leads, they know the industry best, then they will be able to identify who are the key companies under their sectors that should be following the NCII rules. So the list will then be submitted to NACSA, the chief executive, and then finally the chief executive will advise the committee of the final list of companies that are affected. So you will definitely be informed about whether you are selected or not as an NCII entity, and so this will probably be done in the form of official letter sent to you, as well as the list being published on NACSA website, I presume. Okay, so as I mentioned earlier, the sector leads, their job is to also help create guidelines for their sector. So they will be the one that is advising the chief executive of NACSA in terms of any industry specific guidelines for their own sector. So for example, as I mentioned, if you are in the aviation industry, there could be specific system that needs to be protected. So they will advise the scope of the audit and the risk assessment that needs to be done by all the companies under the aviation industry, for example. And the sector leads, actually, they have to obey the policies and the instruction from the chief executive. Failing to do so, there is actually clause in the act for them to be penalized as well. Yeah, the sector leads also can be penalized, not just the NCII entities. So these are the sector leads that have been identified, that have been designated just a couple of weeks ago. So this information actually you can also get from NACSA website. And you are providing the company to the country, and therefore, most likely you'll be selected as an NCI entity and you need to comply. So what exactly are your responsibilities should you be selected? So there are about four main responsibilities in the Act at the moment. Number one is information disclosure to the sector leads and to the chief executive. So you will need to share information about the critical infrastructure, the critical systems that you have to the sector leads and to the chief executive, and any changes that you make to your NCII, your critical system, also needs to be updated and informed to the um, chief executive. So let's say, for example, if you are in the aviation industry, you have a particular system that controls, say, flight scheduling, So if you were to upgrade the system, you would need to inform the chief executive. Maybe you're upgrading to a new version, or you are doing a hardware upgrade. Anything that can cause um, downtime, anything that can cause interruption to this critical infrastructure, the chief executive needs to be informed about it. So you need to share this information. And as I mentioned earlier, the chief executive can actually request any kind of information related to the safety, the security of this NCII. And if you refuse to provide this information, you can be prosecuted. So there are clauses in the Act for this. Secondly, you need to conduct a risk assessment, okay, once a year. Sorry, this is a bit of typo. There's two things here. Risk assessment once a year, security audits once every 2 years. So this needs to be done. The question that normally is asked is, what kind of risk assessment that needs to be done? So at the moment, we don't have that information. As I mentioned earlier, we need to have the code of practice, the guideline to spell out exactly what's the minimum that needs to be done in order for you to comply. And currently, that is being worked out by the sector leads just now, the NCII sector leads, together with NACSA. So expect to have these guidelines coming out in the next months. And after that, you will need to comply with the scope that is specified in this risk assessment and audits. Also, a question that was asked, I think, in the registration was who can perform the audits, or what kind of qualification the company needs to have. So all of this will be advised in the code of practice that will be published. Right now, we don't know. Number three, you need to report cybersecurity incidents. So if you have any kind of breaches, any kind of cyber attacks, ransomware attacks, you need to actually inform NACSA about it. So earlier, one of the regulations that was published was on the details of how you can report these incidents. So this one, notification of cybersecurity incidents, regulations 2024. So in this regulation, it actually goes into detail in terms of how you should report the incidents. Yeah, we go into a bit more detail on that in the next slide, but I just want to mention the fourth responsibility that you have is to implement any kind of code of practice that is released by NACSA. Okay. Well, actually, it's by the government, by the committee. Okay, so talking about responsibility number 3 just now, cybersecurity incident notification. So in the past, I think a lot of organizations do not report whenever they have cybersecurity incidents, um, due to the fact that they don't want the bad publicity. But moving forward, this is no longer possible if you are an NCII identity. You must report within 6 hours. And the penalty for not reporting, which we'll touch on later, actually is very, very high. It involves not just monetary fine, but also jail term. Okay, we don't report. So the first report must be within the first 6 hours. So this 6 hours, the first 6 hours is basically after the discovery of the incident. So if let's say you do have a SOC team that is doing all the monitoring, and they discover the incident 12 midnight, you have to report it before 6 a.m. in the morning, um, before you otherwise you'll be penalized. Yeah. If you don't have a SOC team, then you have to report it 6 hours, since 6 hours, within 6 hours of you discovering the issue. So maybe the attack happened 12 midnight, but you only found when you come into the office at 8 a.m. in the morning. So you have 6 hours from 8 a.m. to make the report. Yeah. So I think some of you probably are starting to think like, what kind of things do I need to have in place, in order for me to comply with this act? So one of the things that that is a pillar to this act is the reporting of um, breaches, right, of security incidents. And to do the reporting well, you need to make sure that you have the necessary tools in place, because you need to have details and evidence, as you see later. So if you don't have things like, for example, safe lock keeping, you don't have EDR, endpoint detection and response tools, you don't have NDR, all of that is going to be areas that you need to look into to help you to be able to do investigation effectively, and to be able to submit the report to NACSA. So that is something that you need to keep in mind. Yeah. So whatever you have right now might not be sufficient in order for you to do investigation and to make reports. So the initial report should include the authorized person who discovered the incidents. Okay. Um, the particulars of the NCII entity. So it means information about your company. And lastly, a comprehensive description of the incident. So what exactly happened? Did you get hit by ransomware? When was it first detected? What application was affected, etc., etc. So this is the first incident report. The second one is to be done within 14 days. Yeah, and this is much more detailed. This is much more detailed. You need to inform NACSA the affected systems, the number of systems impacted, the attacker details. So again, like if you have some threat intel solution in place, you might be able to get the threat actor details. So that would be needed. NACSA would like to know who actually conducted the attack, and then evidence. So this is very critical because a lot of companies might not have the necessary tools or training of the employees on how to preserve the evidence. But you need to do that in order for you to submit properly. Bear in mind that any submission that is not correct or even wrong can be prosecuted. You also need to have other information such as the attacker methods. So all this, again, as I mentioned, have um, report, NASA will provide a system, the N4C system, National Cyber Coordination and Command Center system, where you can actually log in. The authorized person in the company will be able to log in and make this submission. So there are a lot of penalties in the Act, but the two main ones that I want to highlight here, because this is related to the entity, NCII entity. The first is the failure to conduct risk assessment or audit. So the penalty is 200,000 ringgit or jail term for 3 years. The second one is failure to report cybersecurity incident. So this is very easy to slip up, right? So you might forget that you need to report within 6 hours and you don't do that, and you can be liable to half a million ringgit fine, or jail term up to 10 years. So it's the fact that the government includes jail term shows how serious they are in terms of ensuring the cybersecurity of the country. Yeah? So this act is not to be taken lightly. Who are the people that can be jailed, since there's jail term here, right? So the Act says any or combination of these people: the director of the company, the compliance officer, partner of the company, the manager of the company, secretary of the company, or any other similar officers. Basically, the person that is in charge of complying with this Act, they are answerable to any non-compliance. So if you are in charge of cybersecurity in your company, then you have to make sure that you deliver your duties properly. Yeah. Otherwise, you could end up looking at legal woes. Okay. Some of you actually are from service providers, based on the questions that you submitted. So moving forward, all cybersecurity service providers that are providing two types of services at the moment, which is SOC monitoring and penetration testing. You have to be licensed, and the registration for license is opening next week on the 1st of October on our website. So you can actually log in and then you can register. So this is actually spelled out in the licensing of cybersecurity license provider, service provider regulation 2024. Okay, so yeah, I think that pretty much covers what the Act is all about, an introduction to the Act. So as I mentioned in summary, the Act is all about protecting the critical infrastructure, information infrastructure of the country. So we want to make sure that companies are taking care of the critical systems that could, if it were attacked, cause negative effect on the country's economy and well-being. So this Act requires licensed providers of cybersecurity services to be licensed, and then for the companies under the 11 critical sectors to comply with the regulations of conducting risk assessment once a year, conducting audit once every 2 years, to provide or to disclose information to the chief executive of AXA, and to comply with any code of practices that will be released by the government. So that's basically what the Act is in essence. Okay. Now, if you got any questions, you can submit to the chat window, and I will be answering some of the questions that were pre-submitted during the registration process. Yeah, first. So there's a question on whether this act is similar to the DORA Act in Europe. So I don't claim to know about the DORA Act that well, but I did some research and I found that the DORA is actually an act to be enforced very soon in Europe, and it is to safeguard the financial institution. So based on my reading, it is much more extensive than the Cybersecurity Act that we have. Um, so it actually covers more things than our current Cybersecurity Act. I believe the person who's asking this question is coming from a financial institution that is headquartered in Europe, and maybe they are being asked to do certain activities to comply with the DORA, to prepare for the compliance with DORA. So I think that you will find a lot of the things that you've done for DORA probably would help you to also comply with the CSA Cybersecurity Act 2024. But yeah, DORA has a number of key elements like ICT risk management, incident reporting, which is similar to what we have in our act, but it has more. For example, it has third-party risk management, which currently our act does not cover. So next question is on the um, requirement to have a data protection officer in the company. So that is actually under a different act, not under the Cybersecurity Act. That's under the new PPA Act that will be released very, very soon. The second version, the update to the 2010 Act. Yeah, so that's a different bill. Will ISO 27001 or SMS certification be a good benchmark to ensure compliance with the CSA 2024? Yeah, most definitely, because there are a lot of common elements between ISO 27001 with CSA 2024. So both of them try to achieve risk management in terms of audit and assessment, and they also focus on incident response. The only thing is it might be a bit different in terms of the details. Yeah. So we are waiting for the code of practice to be released by the government, like in terms of how the audit must be done, by whom, how the assessment, the risk assessment is done. And just now you saw already how incident response is to be done. So you need to update your existing incident response policy to include the reporting within 6 hours, within 14 days to NACSA through the NC4 system, right? Okay, so this question I think comes from a cybersecurity service provider. Okay, so the first one is what constitutes as the services, cybersecurity services. Is there a full listing? Yes, there is a full listing. It's a very short list at the moment. Only two services: penetration testing and managed SOC. So this is specified under the licensing of cybersecurity service provider regulation, PUA 221. Okay, so you can Google on this. So if you're providing any of these two services, you need to get a license. Next question is, if the company is outsourcing the managed services to a third party, does the company need to apply for license? Yes, you need to apply for a license. And then how can the company protect itself from any legal implication if the outsourcing party has a breach? Okay. So firstly, again, the act at the moment does not prosecute you if you have a cyber breach. So it means if you got cyber attack, you don't get penalized at the moment. You get penalized if you don't report it, number one, and number two, if you don't do the preparation in terms of the risk assessment and the audit, okay, and the disclosure of information to the chief executive. But if you have done all this and you get hacked, or you have a data breach, or you have a ransomware attack, you don't get penalized for that. You don't get penalized for that. The act does not specify that. So, yeah, in terms of the first question just now, right? You have to register as a service provider if you provide any security service. Doesn't matter whether you're doing it yourself or you're outsourcing it. you need to get a license. Yeah. Um, and then the Act also says that a person shall be liable for the same punishment or penalty for every such act. Yeah. Um, of the person's employee or agent, or the employees of that person's agent. So again, I'm not a lawyer, but from my understanding, if you get a third party, you outsource it to a third party, and there is some non-compliance, right? You also be liable. But there are some exemptions. Okay, so if let's say, for example, if you are unaware of the offense committed, okay, you can prove that the offense was committed um, by the agent or by the your employee without your knowledge, then you are not liable. Yeah. Uh, um, there's another question on okay, the question is not appearing here for whatever reason. So the question was actually about what if my company HQ is in Malaysia, but the operation, okay, the operation is somewhere else. So this particular company is doing some plantation. So the holding company here is in Malaysia, and then the plantation is, say, in if I recall correctly, is in Indonesia. Yeah. So if let's say your company is designated as an NCII entity, it doesn't matter whether your operation is Indonesia or somewhere else. You might have some system. Like in this case, you are in agriculture, right? And Ministry of Agriculture already identified you as one of the critical companies, NCII entity, and you have some system that is located, computer system that's located in Indonesia. You still need to comply. Okay, you still need to comply. So if anything happens to that system in Indonesia, you still have to report it. Okay, this is very clear cut in the act because it has an extraterritorial application. So if you look at point 2, it says that the infrastructure, the NCII, can be here in Malaysia or it can be elsewhere. Doesn't matter. Okay, as long as if the system is targeted, is breached, is attacked, it will affect Malaysia, then it will still apply. Yeah, it will still apply. Especially today, as you know, most of our systems are borderless, right? Some can be here in Malaysia, some can be somewhere on the cloud. We might not even know where it is on the cloud, right? So doesn't matter where the system is located. Additionally, the nationality makes no difference as well. So if the person that is breaking the law is not Malaysian, also can be prosecuted. As I mentioned just now, the effect, is outside or within Malaysia, also does not matter. And whether the act of non-compliance is committed inside Malaysia or outside of Malaysia, can be prosecuted. Okay, so I think that's all the questions that we have. Um, if you do have any additional questions, you can actually ask to myself at this email address. I'll be more than happy to assist you with any of those questions. And oh yeah, just one question that I think is very good. The question is on um, whether or what constitutes as a cybersecurity incident. Yeah, what constitutes as a cybersecurity incident? So the Act does not specifically spell out that. So that we need to have probably a code of practice issued later on, yeah, to have more details. My own take on it is small incidents like a virus attack or a phishing email, all these do not qualify. It has to be something that affects the critical information infrastructure that you have in your company, right? So most of your company, you have some critical systems. So those are the ones that will qualify. And if there's an attack to it that is significant, that can affect the running of those systems and your business, then you have to report it. Okay, that's my take on it. But obviously, there will be a guideline, code of practice that will be issued. I believe that will um, spell that out in more detail. Okay, another question here is on the when will the NCI identity be announced, and how will we know about it if we are selected, and whether it will be published somewhere. So I think in the next couple of months, the list will be finalized. Right now, the NACSA and the sector leads are definitely working with each other, but it will take a bit more time on that because the sector leads have just been designated also a couple of weeks ago, 2 weeks ago. And um, yeah, the list will be provided by the sector leads, and then it will be checked by NACSA, and then final recommendation will be to the committee, and then it will be approved. You will definitely know if you are selected. NACSA will definitely get in touch with you. There will be official letters, and of course, there should be a list that is publicized on the NACSA website. I believe. Okay, next question is on service providers. So is there a way to check if a company is a licensed service provider? Yeah, of course. I think there will be an official license, paper license. So if you're dealing with, say, a penetration testing company, you want to know whether they're licensed or not, you just ask them to provide the license, PDF, and I'm sure there will be a listing also on NACSA website, so you can always check against that list, yeah, to confirm whether your service provider is authorized or not, whether they are licensed or not. Okay, so I think that's all the time that we have for today. Um, Thank you very much for your time again this morning. Um, Feel free to contact myself with any further questions that you might have, or if you're interested in any of the cybersecurity products that we carry and the cybersecurity services that we provide as well. So Internet Now, not only we have managed security monitoring, but also we are the market leader when it comes to security awareness training. So we provide security awareness training in the form of online learning, phishing simulation, physical training, to some of the biggest customers here in Malaysia. So thank you very much for your time, and I hope to see you on our next webinar. Goodbye and have a good day.